The courtroom is so quiet I can hear the light humming above my head. 6 hours today, 11 days before that. Somewhere in those 11 days, I stopped feeling my feet. Judge Gerald Birch adjusts his reading glasses and reaches for the final exhibit. He is 62, and his face holds the look of a man who has already decided everything. Prosecution counsel Dominic Hale rises slowly. He moves like expensive men do, certain, unhurried. He lifts a plastic evidence sleeve from the table as though it contains something sacred. Let me tell you who is sitting here. My name is Eleanor Voss. I am 41 years old, a former art teacher of 19 years, and 3 years ago I was convicted of murdering my husband. I did not do it. That note is what sent me to prison, and it is about to keep me there for the rest of my life, unless something changes in the next 60 seconds. Inside the sleeve is a handwritten note. 7 lines on cream paper. My name at the top, a signature at the bottom. Hale tells the judge it is the note I sent to a pharmacy 3 weeks before my husband, Martin Voss, died from digoxin poisoning. My attorney, Janet Bowman, objects. The judge overrules her before she finishes. I drop my eyes to the table and wait for the gavel. In the gallery, 12 rows back, a man in a gray cardigan leans slowly forward in his seat. I do not notice him. But he is noticing something that is about to change both our lives. The night before my arrest, I made chamomile tea, graded 14 drawing assignments, and left Martin a note about his cardiology appointment. 9 years of marriage. He was careful with money, careful with words. We were not unhappy. We were 2 people sharing a house and a last name. Martin died on a Wednesday. By Friday, a detective was at my door. By Monday, I was in handcuffs. The prosecution's story was clean. I had found out Martin was quietly removing me from his $4.2 million estate, built on pharmaceutical patent royalties, and had poisoned him before he could sign the new will. The note from the pharmacy was their proof. A life insurance policy I barely remembered was their second. The jury chose the story that felt most familiar. 19 years of lesson plans. Hundreds of students. A classroom of charcoal sketches. All of it reduced to a motive. In the 3 years since, I lost my teaching license. My house sold to pay legal fees. My mother got sick during my 2nd year inside. I asked for compassionate release. They gave me a 6-minute supervised phone call to an empty room. I stopped crying after that. I picked up a pen and started writing instead, every inconsistency, every detail that didn't fit, every question nobody would answer. I kept writing until the notebook was 47 pages thick. It was on the table beside me that morning, under my folded hands, while the judge reached for his gavel. Most of what happened outside those prison walls, I learned afterward, from Raymond himself, from Janet, from court records, and from journalist Odessa Park. I will tell it the way I came to understand it. The man in the gray cardigan was Raymond Cooke. He was 68 years old and 4 years into a retirement he was failing at. He gardened badly. He watched television he didn't enjoy. When his granddaughter Zara, a first-year law student, invited him to a live appellate hearing for her evidence law seminar, he agreed mostly because it gave him somewhere to be on a Tuesday. He had not expected it to matter. But Raymond spent 31 years as a homicide detective. 31 years teaches you to read handwriting without meaning to. His old partner, Gloria Meade, used to say he read it the way a wine expert reads a glass, by knowing in the gut, not by thinking. When Hale raised that note, the handwriting reached across the room and grabbed Raymond by the throat. The tight leftward slant. The broken crossbar on every T. The double loop on every G that curled back like a question it refused to finish. He had seen it once before. 23 years ago, in a case he had been ordered to close and forget. He drove home, found the file he had kept against regulations, and opened the folder labeled Connolly, Witness Statements. 8 pages. Signed, Dominic Hale. Age 24. Law clerk. He placed both documents side by side. He looked at the G on each one. Then he said quietly, "You arrogant man." The Connolly case opened in autumn 2001. Thomas Connolly was a 61-year-old retired judge found dead in his study from what appeared to be a cardiac event. It would have stayed routine, except Connolly had been preparing testimony for a judicial misconduct inquiry. His diary was going to name 3 members of Millhaven County's legal community. That diary disappeared before the second evidence sweep. The case was reclassified as inconclusive 45 days later. Raymond pushed back. His supervisor, Lieutenant Dean Ferris, told him there was no evidence of foul play and a missing diary proved nothing. Raymond was ordered to close the file. He believed Thomas Connolly was murdered. He could never prove it. The key witness who helped steer the investigation toward inconclusive was a young law clerk who worked in Connolly's building. He filed 8 handwritten pages claiming he had seen nothing and knew nothing. After filing his statement, he moved cities and enrolled in law school. That law clerk was Dominic Hale. Raymond had kept the file because something about that case never sat right. 31 years of homicide work had taught him that feeling was worth more than most people gave it credit for. Now, with both documents in front of him, he understood what he was really looking at. Hale had not made one mistake. He had learned early that he could manipulate the systems around him and had spent 23 years getting better at it. Raymond opened his laptop, built a timeline, and circled 3 cases in the county where convictions had always felt slightly too clean. Janet Bowman had been a public defender for 11 years. She carried 31 active cases, drove a car with a broken air conditioner, and ate lunch at her desk most days. She still believed what she had believed at 26, that everyone deserved someone in their corner who had chosen to be there. The system had just made it very hard to act on that. Raymond called Janet the morning after the hearing. Calmer now, better organized. He explained the handwriting comparison, the 2001 Connolly file, and the 23-year connection. This time, Janet listened properly. Because she had found something on her own. Reviewing the evidence log from my original trial, she noticed the pharmacy owner had described the note as written on cream paper with a pale blue letterhead. But my personal stationery, listed in the house inventory, was plain white. No letterhead at all. Someone had described a note that could never have been mine. "Get me 72 hours, Raymond said. "The judge issues his ruling in 48, Janet told him. "Then 48. "File an emergency motion. Tell the court that new evidence has been identified. You don't have to name it yet, just say it exists." Janet looked at my notebook on her desk. Page 11. The pharmacology term I had flagged at 2 in the morning in a prison dormitory 18 months ago, while holding a pen because I had absolutely nothing else to hold on to. She opened her drafting software and began to type. The pharmacy owner's name was Clement Farrow. At my original trial, he had been calm and careful on the stand, the kind of witness juries trust without thinking hard about why. He said he recognized me as a regular customer. He described the note in detail. He called the police because his conscience required it. The jury believed every word. Raymond found him in 6 hours. Farrow had closed the Alderman Street Pharmacy and was running a small wellness business in a town called Harkers Falls, 90 minutes north. Raymond drove there without calling ahead. Farrow answered the door and went still when Raymond introduced himself. Not frightened exactly, more like a man who had been expecting this knock for a long time. Raymond placed the stationary discrepancy between them, the blue letterhead Farrow had described versus my plain white paper. He waited. Farrow was quiet for almost 3 minutes. Then, I was told what the note looked like. I had never seen the actual note. He had never met me in his life. A man had come to his pharmacy 8 months before my trial and told him about a compliance problem with his dispensing license, a real paperwork issue. The man knew about it. He told Farrow that if he wanted his business to survive, he would confirm what he was told to confirm. Farrow had done it. He had known for 3 years what it cost me. But he had kept something. He called it insurance. He pulled out an old phone, powered it on slowly, and pressed play. The recording was 47 seconds long. The audio quality was imperfect, captured on a phone in a coat pocket, with background noise from the pharmacy's ventilation. But the voice was clear enough. Calm and practiced. It explained what Farrow was to say and what would happen to his business if his memory proved unreliable. Raymond had listened to Dominic Hale speak in that courtroom for 11 days. He was certain. He transferred the recording to a secure device, told Farrow to stop answering calls from that number, and told him to stay at his sister's house in another city until further notice. Farrow was already packing when Raymond left. Raymond called Janet from the parking lot. He described the recording. The silence on the line felt charged rather than tired. "This is witness tampering," Janet said. "This stopped being a civil matter the moment that recording was made." "I know. But if we go to the district attorney now, Hale will know within 24 hours. He has connections inside that building. We need enough that he cannot buy his way out quietly. The judge rules in 31 hours. Get me the forensic document examiner. I'll get you the rest." He drove home. He looked at his garage wall, the timeline spreading across it, names circled, arrows connecting things that should never have been connected. He wrote a new name with a question mark beside it, Peter Strang. He did not know yet what Peter Strang knew. But he knew enough to know it mattered. He picked up his keys and drove out into the dark. Peter Strang was 51 years old and lived 40 minutes outside Millhaven with a large dog and the careful stillness of a man who had learned to ration his trust. He had been a compliance officer at a Millhaven financial firm before a fraud conviction in 2016. His public defender, referred through a legal advocacy group, had initially been thorough. She found internal audit records that appeared to clear Strang entirely. Then, 3 weeks before trial, she withdrew the evidence and told him it wouldn't help. He served 4 years. He came out quiet, careful, and holding copies of everything. The advocacy group that had referred his public defender had a board of directors. One board member was Dominic Hale, 2 steps removed, clean on paper, but present in the structure the way a load-bearing wall is present, invisible until you look for it, impossible to unsee once you do. When Raymond arrived at Peter's address, the house looked empty. A neighbor said Peter hadn't been home in 4 days. His car was still in the garage. His dog was unfed in the yard. Raymond noticed a light on upstairs that hadn't been there that morning. On the front step was a boot print too large to belong to Peter Strang. Someone had been inside. That night, Raymond's phone rang. Unknown number. A low, careful voice said, "You've been asking about my case, Mr. Cooke. Someone went through my kitchen drawers today. But I'd already moved the original." They met at a roadside diner 40 minutes outside the city. Peter sat with his back to the wall and his eyes on the door. He shook Raymond's hand once and waited, the way a cautious man waits to confirm the trust being offered is actually real. Peter talked for 90 minutes. He described the compliance audit, the financial irregularities he had reported, and the legal consultant who had appeared and turned the situation against him. He described the public defender who found his exculpatory documentation and then withdrew it 3 weeks before trial. He had made 3 copies of everything. One in a safe deposit box. One with his brother out of state. And one on a USB drive he had worn around his neck for 2 years, because the weight of it reminded him daily that he was not imagining things. He put the drive on the table between them. The cord had left a pale mark on his skin. On it were records of 3 charitable foundations, legitimate on the surface, but with a current of transactions running through their center that a compliance officer would recognize immediately, payment for services never invoiced, never explained, never meant to be found. One of those foundation trustees, Peter said, is a woman named Harriet Birch. Raymond was very still. The judge's wife. The judge ruling on Eleanor Voss's appeal tomorrow morning, Peter said. He has been financially connected to this network for 4 years. Raymond looked at the drive for a long moment. Then he picked up his phone and dialed Odessa Park. I did not know any of this. I was in my cell, holding my notebook. 47 pages. I had started it 18 months into my sentence, at 2 in the morning, when the sleeplessness and the slow burn of certainty pushed me to a pen. I wrote down every inconsistency, every detail that did not fit, every question nobody would answer. On page 11, I had flagged a phrase in the pharmacy note attributed to me, bioavailability ratio. It is a pharmacology term describing how much of a compound the body absorbs. I was an art teacher. I would not have known what it meant, let alone used it correctly in a written request to a pharmacist. I had flagged it. Janet had read it. Her supervisor told her it wasn't enough to challenge a conviction. Nobody listened. So I kept writing. Not because I believed anyone would read it. I wrote it because the truth deserved a record, even if the only person who ever read it was me. While I sat in that cell, not knowing about the recording or the judge's wife or Peter's USB drive, Dominic Hale was in his office on the 12th floor of the Hargrove building, putting a dark green journal into his bag. He had kept it in one place for too long. Confidence does that to a man who has never been caught. He told himself he was being careful. But a retired detective had already leaned forward in the back row, and the truth was already moving. While I slept fitfully that night, Raymond was on the phone with his old partner. Gloria Meade had retired to a city called Prentville. When Raymond called at midnight, she told him something she had been holding for 6 years. In 2019, someone had called her with a calm, friendly voice and said that if the Connolly case ever came up again, she was to say she remembered nothing. That call had come from Dean Ferris, the lieutenant who had ordered Raymond to close the case in 2001. Ferris had retired from the police in 2007 and moved into civic advisory roles across Millhaven County. He sat on 2 boards. One was the Bar Association board through which Hale had generated his complaint against Janet. Ferris had been there at the very beginning. He had never left the picture. Raymond added Ferris to his timeline and called Vivian Marsh. She had been an associate at Hale's firm for 4 years before leaving in 2018 without explanation. She practiced family law in a neighboring county now and had changed her phone number twice. She spoke to Raymond for 48 minutes. She told him she had once glimpsed Hale's green journal through an open office door, A4, no markings. She had overheard Hale tell another man it would never be anywhere a search warrant could reach. The other man's description matched Dean Ferris almost perfectly. It's a record, Vivian told Raymond. Every arrangement. Every name. Every payment. If it can be found, it doesn't just free Eleanor Voss. It ends careers. At 11:45 that night, Odessa Park published the first installment of her investigation. She called it, The Architecture of a Verdict. It did not name Hale directly. It described a pattern, a quiet, years-long pattern of manipulated outcomes in Millhaven County's appellate courts. Within 2 hours, it had been shared thousands of times. At midnight, Judge Birch's clerk called Janet. The judge had seen the article. He was moving the emergency hearing 2 hours earlier, to 8 in the morning. And he had, the clerk said carefully, called the state's judicial oversight body to make a voluntary disclosure. Judges do not call judicial oversight at midnight unless something has deeply unsettled them. It could mean he was genuinely honest, or it could mean he was genuinely frightened. Either way, it meant he knew his position was no longer clean. Janet called Raymond immediately. He knows, she said. Which part? Raymond asked. I think all of it, Janet said. The foundation. His wife's name in those records. Raymond looked at his garage wall, 23 years of a carefully maintained system. Hale at the center. Ferris providing cover. A judge's household funded through shell money. An innocent woman in a cell. We go tomorrow with everything we have, Raymond said. Everything, Janet agreed. He went to bed at 1 in the morning and lay awake until 4, running through every piece of evidence in order, looking for the gap that could undo it. He did not find one. But somewhere across the city, Dominic Hale was lying awake doing the same calculation, and arriving at a very different answer. I was not told any of this. Janet had decided not to give me the full picture, and I understood later why. A client who knows too much can show too much. If I had walked into that courtroom knowing about the recording, the journal, the judge's wife, Hale would have read it on my face before the first question was asked. So I held my notebook and I did not know. I read it from the beginning, the way I sometimes did when I needed to remind myself I hadn't invented any of it. 47 pages. Page 11. The pharmacology term. The stationary note in the margin. I thought about my mother. About 6 minutes on a prison phone to an empty room. About all the things I would have said if I'd had 600 minutes instead. I was not afraid exactly. I had moved past fear the way you move past furniture you have bumped into so many times in the dark, it becomes familiar. What I felt instead was something colder and more solid, a certainty that if tomorrow went wrong, I would find another way. Another motion, another document, another argument. I was not going to stop. 3 years of wrongful imprisonment had made it very difficult for me to finish. I closed the notebook. I lay on my narrow bunk and stared at the ceiling until the corridor light changed color and I knew morning had come. I had been getting ready for this for 3 years. I was ready. They transported me to the courthouse at 6:30 in the morning. The rescheduling came too fast for Janet to arrange my own clothes, so I arrived in prison-issue clothes and sat in the holding area outside courtroom 4 while Officer Tran, a guard who had never once been unkind to me in 3 years, brought me a coffee from the vending machine without being asked. I thanked her. I drank it slowly. Janet arrived at 7:45. Her document bag was significantly heavier than I had ever seen it. She told me what I needed to know. Raymond Cooke. The handwriting comparison. Clement Farrow's recantation and the recording. Then the detail that stopped my breath. The cream paper the note was written on came from a brand discontinued in June 2019. I had been arrested in October 2021. The paper hadn't been sold for over 2 years before I was supposedly meant to have used it. I asked how the handwriting analysis would be presented and whether Farrow's affidavit was properly attached. Janet said it was. The recording was Exhibit 14. I looked at the courtroom door. Is this enough? I believe so, Janet said. I stood. Then let's go in. The courtroom was full, journalists, law students, attorneys from other firms who had read Odessa's article overnight. I sat down, placed my notebook on the table, and folded my hands over the cover. At exactly 8 o'clock, Judge Birch walked in. He looked like a man carrying something heavy in both hands. Before the hearing began, Judge Birch made 2 statements. The first was that overnight he had disclosed a potential conflict of interest to the state's judicial oversight body. A charitable foundation connected to a member of his household had financial ties that required full transparency in light of the evidence now before the court. He chose to continue presiding with that disclosure on the record because, he looked directly at our table, Eleanor Voss could not afford another delay. He said my name like it was a reason. I had not heard it said that way in 3 years. The second statement was that he had reviewed the defense's emergency evidence submission from midnight until 20 minutes to 4 in the morning. He was prepared to proceed. Then he looked at Dominic Hale. Mr. Hale. I have some questions for you. He asked about the exhibit note. He asked about the paper stock. He asked whether Hale had any knowledge of the paper's origin. Hale said he did not. Then the judge read Dr. Simone Achebe's forensic analysis into the full record. 17 separate findings. The leftward slant. The broken crossbar. The double-looped lowercase g. He read each one aloud in the level tone of a man reading a list of charges. When he reached the final finding, a probability of less than 1 in 800,000, he set the document down. He looked at Hale for a long, deliberate moment. The courtroom was absolutely still. The judge asked Hale to write the first 3 sentences of the exhibit note in front of the court. Hale's criminal defense attorney stood and objected on Fifth Amendment grounds. The judge noted it. Then he looked at Hale. Hale waved his attorney back down. Even now, he believed composure was enough to manage a room. He picked up the pen, wrote the 3 sentences, and pushed the paper across the bench with perfect steadiness. Dr. Simone Achebe had been sitting in the gallery. The judge called her forward. She took the oath, set her magnification loupe on the railing, and looked at the fresh sample beside the exhibit note for 30 seconds. Then she said, clearly, without hesitation, in the voice of a woman who had testified in 140 cases, same hand. The gallery erupted. The judge called for order. In the noise, I looked at Dominic Hale for the first time since entering the room. His face was arranged correctly, the muscles doing their work. But something behind his eyes was working very hard. It was the expression of a man who has run the same calculation he always runs and found, for the first time in 15 years, that it no longer resolves in his favor. Then the recording was played. 47 seconds of his own voice filled the courtroom. Calm, practiced, instructing a man how to lie about me. When it ended, the silence it left behind was the loudest thing I had ever heard. Hale's criminal attorney stood and announced his client was invoking his Fifth Amendment right across all remaining questions. It was the correct legal move. But in a courtroom full of journalists and law students, choosing silence about things you did not do carries its own meaning. Judge Birch noted the invocation and called a recess. During those 27 minutes, I sat at the defendant's table with my notebook under my hands. Janet was in chambers with the judge and Adrian Winslow, a deputy district attorney who had arrived 45 minutes into the hearing, spent 20 of them reviewing the evidence on a tablet, and then quietly introduced himself to the court. I did not know what was being said in that room. I knew only what the evidence looked like from where I sat, a forensic expert confirming the handwriting in open court, a recording of Hale's own voice through the courtroom speakers, a financial trail from Shell Foundations to a trustee named Harriet Birch and then back through 23 years of arrangements to a lieutenant who buried a case in 2001. I thought about my mother. About 19 years of students whose names I still knew. About the note I left Martin the night before my arrest, the last ordinary thing I ever did. The chamber door opened. Janet walked back to the table and sat beside me. She said nothing. She took my hand briefly, the way you hold something when you know it is about to change. Judge Gerald Birch settled into his chair. He folded his hands on the bench and looked at me. Mrs. Voss, he said. My hands were flat on the notebook. This court has reviewed the evidence submitted by the defense. The forensic handwriting analysis, the sworn recantation of the pharmacy witness, the audio recording, and the financial documentation collectively establish, to this court's full satisfaction, that the principal evidence used to convict you, the note attributed to your authorship, was fabricated. That fabrication was carried out by an officer of this court. The integrity of your original trial was fundamentally compromised. I was not breathing. I do not think anyone in the gallery was breathing. On the basis of these findings, this court is vacating your conviction in its entirety. You are to be released from custody immediately. The verdict is set aside. You are not guilty. You have never been guilty. And this court formally records that finding. 2 officers entered before the gallery had processed what the judge had said. They moved toward Dominic Hale. His attorney made 3 objections. The judge overruled all 3 without looking up. I stood because Janet was standing and had her hand under my elbow. I looked at the door. Then I looked at the gallery, and in the 12th row, I saw a man in a gray cardigan looking back at me with the quiet expression of someone who has finally finished something that needed finishing for a very long time. I didn't know his name yet. But I knew exactly what he had done. The release paperwork took 4 hours. Janet admitted she had a change of my clothes in her car the whole time. She had believed this would happen even on the days she told herself she wasn't sure. I changed in a courthouse bathroom and stood at the mirror for a long moment. The person looking back was familiar the way someone you haven't seen in 3 years is familiar. You need a moment to re-establish the acquaintance. I walked out of the courthouse at 2:30 into a cool gray afternoon. Cameras. Odessa Park among them. Janet beside me. Raymond was on the steps. He had his hands in his pockets and the still expression of a man who has discharged an obligation he did not take on lightly. I walked past the cameras and stopped on the step below him. "You were in the gallery," I said. "First row by the end." I moved up. I held my notebook out to him. He shook his head. I pressed it into his hands anyway. "I kept the record," I told him. "You knew how to read it." What came after was not simple. Hale was charged on 7 counts. His firm closed in 3 months. Dean Ferris agreed to cooperate in exchange for a resolution that included reopening the Connolly case. Thomas Connolly's family received a call they had waited 23 years for. My teaching license was reinstated 7 months later. I used part of the civil judgment to start a legal research grant at the State University, in my mother's name. 11 months after I walked out of that courthouse, Janet called me. She told me about a woman named Odessa, a teacher, convicted in 2016, still inside. Her file showed the same damage, evidence withdrawn, a witness who changed his story, a note that didn't match her stationery. Her defense came through a network tied to Hale's firm. Odessa had a notebook. I thought about 3 years in a cell. About 6 minutes on a prison phone. About 47 pages that no one read until a retired detective paid attention to something everyone else walked past. "Tell her to keep writing," I said. "Tell her someone is coming. I do not know what justice looks like before it arrives. I only know what it felt like to sit in a dormitory at 2 in the morning, certain I was the only person who could see what had happened to me, and to write it down anyway. Not because I knew anyone was coming. But because the truth deserved a record, even if the only person who ever read it was me. If you know someone whose story has been buried, someone sitting in a room they do not belong in, holding a notebook that nobody has read, share this story with them. Tell them the truth does not disappear just because it has been ignored long enough. Tell them a man in a gray cardigan might be leaning forward somewhere right now, reading something that everyone else walked past. Keep writing. Keep the record. Someone, somewhere, is paying attention.